Legislation like this, however well-intentioned, inevitably affects the way in which we start to assess the quality of life. We have no right to assess the quality of a disabled person's life. If we are going to go into that sort of society, well, Lord help us all. I think it would be a dystopian nightmare. The law should not discriminate positively or ignore the prosecution of cases because of so-called cultural sensitivities. We went through a period 15 or so years ago where there was a nervousness, there was an inexperience perhaps. There can never be a cultural excuse or explanation for child abuse. I think that the Lord Chancellor should have responsibility for the money and the administration of justice. Plain and simple. If you're answerable in Parliament, as I was, for the money and for the administration of justice, you've got to have your hands on the controls. And I don't think that the modern Lord Chancellor does. I don't think the Lord Chief Justice does, frankly.
This is the Lord Chancellors, where politics meets justice. Brought to you by the University of Law. This week, I'm joined by Sir Robert Buckland. Sir Robert is a senior Conservative politician and barrister. The MP for South Swindon for 13 years, he served as Solicitor General before being appointed Minister of State for Prisons and Probation. Under Boris Johnson, he was made Lord Chancellor and Justice Secretary, a role he held until 2021. Born in Llanelli, Wales, he attended a local comprehensive school before studying law at the University of Durham. He went to the bar, specialising in criminal law, and practised there for nearly 20 years before entering politics, first as a county councillor and then as an MP from 2010. As a backbencher and minister, he favoured reforms such as increased prison sentences for grooming gangs and better protections for victims of crime. As Justice Secretary, he oversaw the criminal justice system during the COVID-19 pandemic. In that role, he was a popular politician, and when moved in September 2021 to make way for Dominic Raab, it was generally regretted within legal circles. Sir Robert was then appointed by Liz Truss to serve as Secretary of State for Wales in July 2022, but stepped down in October that year when she was replaced by Rishi Sunak. He is a member of Foundry Chambers, senior counsel at Payne Hicks Beach Solicitors, and a consultant at DAC Beechcroft. I began by asking Sir Robert about the state of the criminal justice system.
Well, I'm afraid that the criminal justice system's been the victim of two key things. First of all, the historic decline in funding for both courts and prisons, which I think has been an issue not just for the last 15 years, but for much longer, going right back to the beginning of this century, in my view. And then secondly, the continuing impact of the COVID crisis. The lockdown had a significant impact upon jury trials, and we can see the consequences of that now. But let's not forget it also had an impact on the way we manage prisoners, and that's worth looking at too.
Absolutely. So you're not putting any blame at the door of the Conservatives for the last 14 years?
I think that the decisions that were made just after the 2010 election to really take the knife to the justice budget were, I think, on reflection, too harsh. A relatively small part of public spending, which took one of the heaviest brunts of the necessary savings that had to be made in the aftermath of the economic crisis. I think since then we've seen the justice budget somewhat recover. I was happy to play my part in helping to recover that budget back in 2019. But the long
When
term,
you took office?
When I took office, and I had both Rishi Sunak and Boris Johnson who were personally very vested in it, and we had increases. But clearly that came against a backdrop of long-term decline.
It was too late, perhaps.
Well, never too late, but it takes a longer time in order to climb out of a period where we've seen courts really struggling and our prison system bursting at the seams.
Now, we've got a number of proposals floating around about how to tackle the real crisis in court backlogs, one of which is to perhaps remove the right of defendants to elect trial by jury for the middle ranking swathe of cases. What's your view about that?
Well, I think we need to be cautious about this. I'm entirely in favour of having a unified criminal court. That would be to abolish this old demarcation between magistrates and the Crown Court. It's been an idea that's been around for quite a while, actually. Had I been even longer in office than my two and a half years, I was going to seriously look at how we unified the criminal court. And I think there is a case to create an intermediate tier, but I think eroding the right to trial by jury is a step we should take very, very slowly, if at all. I'm a great believer in jury trials. I didn't use COVID as an excuse to get rid of them. The furthest I went was to pave the way for remote juries. But the other problem is this. There's a backlog here and now. I don't believe that changing the future status of certain types of offence to reduce the jury option or to remove it is going to solve the problem now. Are we saying that midway through existing criminal cases we're going to remove the right to trial by jury? I think that's a very difficult, if not impossible, thing to do, bearing in mind the principle that you don't apply laws retrospectively to affect either criminal offences themselves or criminal proceedings. And therefore I don't think it's an answer for the short term.
So if neither that or an intermediate court would solve the problem now, then what can be done now?
Well, I think what can be done now is for us to scale up the way in which we use technology. Now, we've moved to digital case management. That was not an easy thing to do, and it still has its critics. But I think that when you walk into a Crown Court and you see a paperless environment, you know that people have moved with the times. I think that there are systems out there and technology out there that can help speed up both the administration of justice and the work that judges do themselves. I'm unusual in the sense that I was, I think, the only modern Lord Chancellor to have sat as a judge. I was a recorder for a number of years, and I've sat in the chair, and I know how precious court time is and how difficult it can be to achieve maximum efficiency. And it does seem to me that there are technologies out there that can help you marshal the facts and the evidence in an automated way, which then allow judges to do that work more quickly and then make the decisions that they need to make, either about sentences or indeed the way in which they direct juries as to the facts and the evidence in cases. And indeed, in complex cases, why not look at technology in order to help jurors marshal the evidence in a way that will help them reach verdicts that they are sworn to do. So that instead of doing, say, 4 sentences in a day, perhaps 6 or even 8 sentences could be passed in order to achieve that greater efficiency. That's what we need to be doing now.
And what about more money for judge sitting days? In other words, paying judges to sit for more days than they do now, because courts stand empty.
Well, I agree.
And the Lady Chief Justice has recently been turned down in her request for more money for that purpose.
Yeah. Well, I lifted the sitting day restriction during COVID. I inherited a situation where the sitting days had been reduced drastically. I made a slight increase in my first few months as Lord Chancellor, and then I removed the restriction altogether, which was only reimposed by this new government. I think it's a mistake. I think that they should, instead of imposing restrictions, they should be scouring the country and the circuits to find suitably trained recorders and judges who are able to, perhaps they've got another type of ticket, perhaps they're doing family work, who are able then to cross-qualify and do criminal work. That's what we did during COVID. I remember issuing an instruction to make sure that as many available recorders were certified in crime to come and sit and come and help us. Because there is a supply issue, and there's also a supply of barristers issue in the sense that often it's difficult to find prosecutors. Cases are being adjourned because of unavailability of counsel. Now that's a more, I think, stubborn problem that we're not going to solve in a hurry.
Is that to do with fees?
Well, I think historically it's due to the fact that the criminal bar was not seen as a place for ambitious barristers who wanted to make a career to do that. I think that's a terrible shame. When I came to the bar in the early 90s, the criminal bar was still a place where you could have a fulfilling career and have a decent income. And I was one of the beneficiaries of that. But I noticed progressively as I got more senior that I found that there were fewer juniors around coming into crime, and that you were having to pedal harder and harder in order to make the same income. Something went wrong 25 years ago. And it's only in recent years that we've started to see a real acknowledgement that that has to change. And I'm very proud that I was the person, the Lord Chancellor, that asked Lord Bellamy to do his report, which I think was a significant intervention. It's unfinished business because some of that report has not been implemented, but it was, I think, a significant uplift at a time when criminal barristers really needed it. But I accept that more now needs to be done.
More needs to be done. The other, I suppose, big crisis at the moment in the criminal justice system is prison overcrowding. Now, you've mentioned COVID. At the time, you were Lord Chancellor, and Dominic Cummins, who worked with Boris Johnson closely, he has accused you of proposing to release all prisoners at that time to solve the crisis in prisons. Is that correct?
That's an utter lie, complete untruth. Dominic Cummins had nothing to do with the prisons issue. I never spoke to him once about the prisons issue. I dealt with the Prime Minister a lot, and I dealt with Munira Mirza, who was head of the policy unit. We made sure that we didn't have to release thousands of prisoners during COVID. And in fact, the way in which we managed the spread of COVID in prisons was one of the success stories of the government, in that we prevented the disease from getting into prisons through quarantining, and that we saved lives. Only about 100 or so prisoners died with COVID during the entire epidemic. And to say that I wanted to have the keys and open the prisons is just a downright lie. I made sure that there was an early release scheme in order to allow that flexibility that could have allowed a few thousand prisoners to be released. But you know how many we released under that scheme? 250. And they were people with underlying health conditions, pregnant mothers, people who I judged personally to be a low risk, because I can tell you, I looked at every case and they would only be released if I thought that it was appropriate. Because as the Justice Secretary, I had responsibility ultimately for the management of our prisons, and I wanted to make sure that people who were released weren't going to go on and reoffend. And that was a success. So what he said is lies.
But what we've had recently, of course, is early release for thousands of prisoners. Are you in favour of that?
Well, look, I'm not in the hot seat at the moment, and I think it's a difficult decision for any Justice Secretary to make. They'd only do it if it was absolutely necessary. What I do think is if you're going to have an early release scheme, you need to manage it very, very carefully, and there needs to be close ministerial attention paid to the types of prisoner being released, the timing of release, the numbers, so that you're not swamping the system with lots of cases where people are being released without accommodation or without a plan as to how to supervise them in the community. I think that's unforgivable. And I've seen a number of cases of reoffending. Frankly, in my view, all that's avoidable if there real care is taken in order to calibrate releases with minimal risk to the public.
Well, we can't build prisons overnight. So that was something that perhaps could have been done in the 14 years of Conservative administration, more prison building.
Yes, and I'm glad to say that I was responsible for the beginning of the largest prison building programme since the Victorians. The new prison at Wellingborough, the new prison in Leicestershire, now open, were part of the programme that I was given the money for by Rishi Sunak and Boris Johnson, £4 billion prison building programme. It's hit delays, mainly because of the planning system, and also because the way the Treasury authorises the MOJ to spend money is quite a restrictive one, and I believe can lead to inefficiency. The model that is being built, the modern prisons are humane, they are safe, they are the right size, and I think the model should just be repeated time and time again. But we have a planning issue, and when you've got a local MP who is protecting their patch, that can hold things up quite significantly. We've seen that in a number of cases, unfortunately.
So meanwhile, what can be done about the prison crisis? I mean, have you any ideas, or is it going to be more release, or sentencing reform or what?
Well, I think that there's a combination of approaches that need to be taken. I think that when we look at the overall numbers of prisoners, we always forget about who is in there. And I think it's important that we jail the right sort of person. We need to protect the public from serious violent and sexual offenders. I think that other types of offender who might not pose that sort of risk, we can deal with in different ways. And I think particularly of short sentences, which time and time again are shown to be ineffective because of the reoffending rates, but which need an alternative that is not just community-based, but that is technology-based. And that's why I advocated in the white paper that was published in my time as Lord Chancellor, the creation of, in effect, house arrest, the use of curfew and the use of tagging in order to restrict the liberty of an offender quite considerably, but to make sure that they weren't occupying a prison cell that could be occupied by an offender who posed a real risk to the public.
Well, we have tagging, don't we?
We do, and I scaled it up.
So are you saying scale it up even further?
Absolutely. I mean, we piloted sobriety tags, and when I was Lord Chancellor, I said, right, roll them out, because the evidence was overwhelmingly positive, that there was an over 90% compliance rate with them. That, in other words, they were reducing reoffending, cutting crime. And therefore that was done. The necessity of having tagging seemed to me not just a COVID imperative, but also a really important opportunity for us to use that technology as a direct alternative to sending people to prison for, say, only a couple of weeks, where, you know, there's nothing the system can do apart from warehouse these people with a huge impact on resources, prison officer time, and organisational resource. And there, I think, we can start to make a real difference in prison management.
And presumably you support scrapping 1 year sentences of up to 1 year, do you? Short-term sentences?
No, I don't. I think that every judge should have the option of jailing somebody who's persistently failed to honour community sentences, suspended sentence requirements. I've been there. You know, I've had to do that reluctantly.
You've sat as a judge as well as being a criminal barrister.
I have, and there are sadly times when that has to be done. So abolishing them, I think, would be wrong. It was done in Scotland, and there's no evidence from their change that it reduced reoffending. There have got to be other ways of doing this rather than always resorting to the law as somehow a quick fix to solve problems. It's the same with increasing magistrates' court powers. You know, that was done after my time, and all it did was we saw a spike in prison admissions. Don't always go to primary legislation as an answer to operational realities.
Well, now, what about the impact of sentencing on prison numbers? We've got a review under David Gauke, who was also Lord Chancellor, held your position. And one of the things I imagine that they'll look at is the length of sentences for the most serious crimes as well as shorter term sentences. One of the proposals, I think this is also being looked at by the Law Commission, is to get rid of mandatory life sentences for murder. Do you have a view about that?
Well, look, I think this is really important work because a number of our senior former Lord Chief Justices and senior criminal judges now retired have traced back the increase in sentences for serious violent and offences in particular to the change that we made to the murder sentencing laws 25 years ago. I think they're right about that. However, I would say this. I think it's right that we send serious violent offenders to prison for longer. I'm glad we do. And when I was in office, I made sure they stayed in for longer because I brought back the old 2/3 rule for people who served sentences of more than 4 years.
Meaning by 2/3 that they must serve 2/3 of their sentence,
before
not be released at the halfway point.
Yeah, which was scandalous. The Labour government in 2003, and it came into effect in 2005, brought this in. Scandalous. It led, I think, to a real collapse in confidence out there, people blaming judges for what was a government decision. If you're going to have longer sentences, the consequences are that these serious violent and sexual offenders need to stay in prison for longer. I'm not making any apology for that at all. I don't like serious violent and sexual offenders. I think they're dangerous people and I want them locked up. But having said that, that doesn't mean that therefore across the board you have to throw the book at all types of offender. There are much more intelligent ways that we can deal with other types of offender, but that will require big investment and further investment in our probation service, in technology, and in the way in which we supervise offenders in the community. Because all it takes is a couple of bad cases, the public's confidence will be eroded if we get this wrong.
Absolutely. So to be absolutely clear, so far as mandatory life for murder, you would not want to scrap that or consider second-degree murder.
To finish your point, I am all for looking at different degrees of murder, because I think there is a yawning gulf between, at the moment, the choices for juries between a conviction for murder and a conviction for manslaughter. And we can see the courts having to grapple regularly with manslaughter sentencing that can never, ever reflect with nuance the type of offending that they have before them. The gulf between the two is just too big. And it results then in difficult and inelegant and frankly imperfect solutions being brought forward by government to deal with particular types of manslaughter. And what you do, you've got at one end, remember that terrible case of PC Harper, the young police officer dragged to his death by people who were convicted of manslaughter, a terrible case that both I and the then Home Secretary, Priti Patel, had to deal with. And then you've got the other end, the gross negligence manslaughter of, say, a nurse or a doctor, where something disastrous and tragic happens and there's a death. Are those two types of homicide the same? I do think that there is a strong case to make for degrees of homicide and degrees of murder in particular, to allow for cases where the intent to kill isn't part of the allegation, it's an intent to cause really serious injury, then that can be dealt with in a different way.
And the punishment can more appropriately fit the crime.
Correct, but I think you have to go through the exercise in that order. So you have to determine whether or not you do have a multi-degree murder offence, and then look at sentencing. I think if you do sentencing first, you put in the cart before the horse, I think.
Now let's go back and talk a bit about your own personal career. You read law at Durham University, and then you became a criminal barrister. Why did you choose law?
Well, law's in the family. My father was a solicitor, senior partner in a law firm in South Wales for many, many years. He used to sit as in his day, a deputy registrar, doing civil cases mainly, and he lived his life in the law. My brother is also a lawyer. He was a trust and tax lawyer for many years. He was president of the Society of Estate Practitioners and is now working overseas.
So law very much in the family?
Very much in the family. I'm the black sheep in that I went to the bar and enjoyed all types of work. I did general common law 35 years ago. That's what you did.
Yes.
So I started with PI, personal injuries. I did family law, care work, but I really loved crime. And I ended up, after a few years, specialising in criminal legal aid work.
What was it you loved about crime?
I think I liked the people. I liked the other barristers. I liked the atmosphere in court. I liked the fact that you were out in the field every day. And frankly, it was a fascinating panoply of cases, some tragic, some, with a certain black comedy to them, let's be honest about it. And yet the standards that you had to apply every day were high. It was an ethical challenge every day. And the only way you get better is by experience. And you learn, you improve, you see other counsel doing the job brilliantly, you learn from them, you learn from judges. I've got a lot of judges, some of whom are no longer with us, from whom I learned so much about doing the job. And I prided myself on being as good an advocate I could be. I used to get up every day and say, you're only as good as your last case. And for me, that was a very important principle.
It's like journalism. You're only as good as your last story.
Yeah, and when the kids came along, I can remember getting up, 5 a.m, preparing cross-examinations before the children started to wake. I'm much better in the morning. So I'm not a night owl. I would, read the case, I would prepare, and then about 10, I think, I can't do this anymore. I'll get up early. And then at 5, that early morning preparation, that was the golden hour for me, in particular to prepare cross-examination, because that is the most important part of the criminal trial. I mean, it's all important. The closing speech is important, but I think that cross-examination is a huge skill.
You specialised, didn't you, in the end in prosecuting? Did you both to prosecute and defend?
Oh, I did both, and I would say at the end, my practice was 50-50. I mean, I was on the Attorney General's list. I was a grade 4 prosecutor as a junior, so I did a lot of heavy sexual abuse cases, often involving children. I did a lot of drugs cases, drugs importation, multi-handed cases. I was a leading junior, so I would often have a junior to help me with my case preparation, and I was on my way to continuing at the criminal bar. And then Parliament intervened. I became an MP.
Well, how did that happen and why? I mean, had you always had a hankering after politics?
Always had a hankering for politics, loved politics. It was a hobby for me for many years. I was a county councillor briefly in the 90s, but the bar was my life. But politics was a real passion. I stood a few times in the 90s, then gave it a rest for a bit. And then in 2005, I stood again in what became my constituency, just missed it by about 1,300 votes. And then in 2010, I won it.
Have you been torn between the two professions? I mean, where is your real love?
Well, I have. And I was told years ago by senior members of the bar, you've got to make a choice. You can either be a brilliant barrister, you can be a brilliant politician. You can't be both. And I thought, sod you. I'm going to do the both. I'm going to do the both. I'm going to prove you all wrong. And I'm really proud that I was able to be, a successful barrister with a busy practice, a part-time judge, and then to be an MP, and then a law officer, and then Lord Chancellor, and now here I am back in the law. You can do the both. It takes a lot of work and a lot of energy, but you can do it.
Particularly once you're in government, and obviously then you can't practice.
Of course. The only years I didn't have a practicing certificate were actually my years as Lord Chancellor. And I well remember the elation of having been appointed Lord Chancellor, having a phone call with the then Lord Chief Justice, Lord Burnett, Ian Burnett, to tell me that I had to resign as a recorder. And I can tell you I wasn't very happy about that because I didn't want to resign. I wanted to keep my appointment in abeyance. Obviously, I wouldn't have sat as a recorder during my time as Lord Chancellor.
But keep it there.
But keep it there and then come back to it.
Yes.
But no, I've had to resign. So one of my great regrets is that I'm no longer a member of the judiciary.
Can you go back to that?
I can apply and go back to it.
Might you?
Yes, I might. Because I enjoyed sitting, and I think it also taught me a lot about how to do the job from the other side of the bench, the advocacy bit.
Absolutely.
And
yes.
I think, having sat in the hot seat, you instinctively know about the pressures that judges are under day after day, and the quite lonely nature of the work that they have to do.
You, as Lord Chancellor, dealt a lot with the judiciary and got to know them quite well. Tell me about your time as Lord Chancellor. What were the best bits and the worst bits of it?
Well, the best bits were the fun bits, as I called it, the ceremonial bits, the state opening of Parliament, making sure I didn't trip over the robe, making sure the Queen had the speech and that she didn't turn over the wrong pages.
Nerve-wracking?
Of course it was. I had to get it right because we had to practice.
Yes.
And the Earl Marshal, the Duke of Norfolk, made sure that I did it right, because there's a moment when I have to go up to the throne,
yes.
bow and give
up
the
two
speech.
Or three steps, isn't
Up 2 or 3 steps. There was a big argument about whether I should be walking backwards. I wanted to, but I think there were nerves.
Yes.
So that didn't happen. Though I did notice Alex Chalk did a backwards walk on his one time presenting the speech. So kudos to him for doing that.
Yes.
Those were the fun bits. The Lord Mayor swearing in, that was great fun. That involved drinking extraordinary concoctions of port and brandy at an inordinately early hour on a Monday morning. That's all fun. I think the difficult bits were frankly, the serious prison issues. I was asked at the beginning of my time, do you want to see details of every death in prison? Some ministers don't want to see it, others do. And I said, well, I do, because I feel corporally responsible for every prisoner, and I want to know
the circumstances of each death.
Yes, I want to know why they died, what happened, was there a history of self-harm, what was the background? And so every death was reported to me personally so that I would then read about it and knew about what was happening. And I felt that was a very important way of keeping me very, very close to the very awesome responsibility of having prisons in your portfolio. I used to have this knot in my stomach virtually every day about prisons and about whether some terrible disaster was going to happen that was going to lead to loss of life, and whether it was disorder, fire. Fire is the biggest threat in our prisons. There are so many fires that are started either accidentally or deliberately, and it's therefore imperative that we have the best systems in order to protect not just the prisoners but also the staff who are on the line. So that was the other end of it, this onerous and incredible responsibility.
So the prisons was the
system.
toughest part, because at any minute something could flare up or blow up and be out of control. What about the judges? Did they flare up? Were they out of control? How did you get on with the judges?
I got on well because I knew most of them. I was very fortunate in that, of course, I'd been of the judiciary, albeit in my part-time role.
Yes.
I'd appeared in front of a lot of them. I'd worked with some of them as counsel, so I knew a lot of them, and they knew me.
Any difficult moments? I mean, they would always be wanting money, and they would be coming to you, no doubt, to argue for it.
Always wanting to come and argue about money, which was my job and my role. We had joint responsibility for the Courts and Tribunal Service, a rather odd hybrid agency that I don't think, frankly, works terribly well. And
I'll come back to that. I'd like to ask your view on that.
But of course, we had a few moments of constitutional sensitivity as well. We had the prorogation crisis.
Indeed.
We had the UK Internal Markets Bill issue back in 2020. There were flashpoints where the Lord Chancellor was, frankly, called upon to defend the judiciary. And again, I did that. I can remember on one occasion during the build-up to the prorogation case that the Scots Court heard one of the applications, and I think it was the Inner Court of Session allowed the appeal, which of course then became the Supreme Court case. And there'd been briefing inside number 10 that this was politically motivated. I wasn't going to have that, because to accuse judges of being politically motivated crosses the line and starts to undermine the rule of law.
What? Were they somehow saying that they were bringing in the Scottish appeal so that they could justify a ruling in that direction? In other words, that prorogation was wrong?
There was an adverse ruling. If you remember, the English court said this is not justiciable, it shouldn't be before us. The Scots court took a different view. And it was from that different view that was adverse to the government that one or two loose tongues somewhere suggested that somehow it was politically motivated. So I issued what was then called a tweet to say that our judiciary are world class, they're impartial, and we respect the rule of law. And I think that sent an important signal to the judiciary and to the wider legal world that here was a Lord Chancellor who was going to stand up for them.
That was your role, and you were going to do it. But of course, your predecessor, Liz Truss, had not done that. Well, famously, in a similar ruling, not quite the same, but on triggering Brexit, that also brought the judges a lot of opprobrium.
I was very mindful of that. There was, I think, a very critical delay and a failure to come out early enough to say...
By Liz Truss.
Absolutely. And I think the Lord Chancellor there has to act as Lord Chancellor. He doesn't need to talk, she doesn't need to talk to advisors in number 10 or to take political advice. You do that in accordance with the oath that you've taken. And, there were other occasions where, I would have to say warn Cabinet about the importance of respecting the rule of law. If somebody had said something out of turn in terms of suggesting or imputing political motivation. And I took that part of the job incredibly seriously.
Well, how difficult was that? Because, of course, Boris Johnson's decision to prorogue Parliament came in for a lot of flack, a lot of criticism. He's been accused of having no time for the rule of law and trampling all over it. And of course, the Supreme Court ultimately said he acted unlawfully. What was your view about that?
I think that my personal view of the Supreme Court's ruling was that I thought it was rather an eccentric one, in the sense that they didn't just rule that prorogation was unlawful. They then went on to say that the prorogation proceedings themselves were not proceedings in Parliament, which I think is just wrong. And to have gone that far, I think, was unnecessary. I think that looking back, the government erred by not explaining properly through written submissions and evidence about why it was that they made the decision to prorogue for such a long period. I think there was a woeful absence of cogent reasons that the court could have looked at in order to then balance the decision.
Because they did not submit evidence as to their reasons, did they?
No, they didn't.
And that was one of the main causes for the decision.
I agree. And courts will need evidence. Even a Supreme Court, which normally is looking at the law, there needs to be substance to why it was that this was done. Now, there were plenty of arguments. There was a conference recess. There were conferences going on, which always means that Parliament isn't sitting at that time, and therefore there could have been arguments put forward. I mean,
did you advise Boris Johnson over this?
No, it wasn't my role to advise him. That was much more of a law officer role than and I'm very conscious of the fact that I was not a law officer. But I do remember saying in Cabinet, we need to be very clear about the reasons for this, because this is a long period. And I think, looking back, the timing of the way it was done, I know there were reasons to do with an obscure Northern Ireland piece of legislation that had been passed a few months before that meant they felt under pressure to do it early. Looking back, did it really help the government make its case about the obstacles of Brexit? Now, I'm not sure it did. I think there was a need to explain to the country politically that this was a Prime Minister who was trying everything he could to get Brexit done, but Parliament wasn't allowing him.
You did not
and that's, I think, is the context in which you need to look at it.
Yes. You did not think that Boris Johnson had a cavalier regard for the rule of law?
Not particularly. I think Boris Johnson's a man with conflicting angels. He's one of, if he was a cartoon character, he'd have these two angels, or the devil and an angel. And my job is to be the angel, to say, now look, Prime Minister, rule of law. This is what we're about.
Did he listen when you said that?
He did. He did. Sometimes reluctantly, but more often than not, he did. And therefore, whilst there were times when I would think, oh gosh, this is a bumpy ride, and if it goes too far, I'm off. I didn't, in the end, have to press the ejector button. Well, of course, he did it for me, and that's another story.
Could I ask you a bit then about the actual role of the Lord Chancellor now? 20 years ago, as you know, the role was reformed and it became a different job entirely. And of course, as you've alluded to, responsibility for prisons, courts, legal aid, judges, all in one department. Is that a good reform, and is it working?
It's not a good reform. I think that the Labour government made huge errors, and the whole basis of their reform was based upon one supreme misunderstanding about the British Constitution, in that it is a purely separation of powers constitution, and that somehow we need to put that above everything else. It's not. We're a checks and balances constitution. Yes, there are separations within it, and it's imperative that the judiciary operates separately from the legislature. They need to, that's vitally important in terms of our reputation for law and for a rules-based system, and no interference with them in their judicial function. But within that, there are lots of checks and balances that a traditional Lord Chancellor would perform. The Lord Chancellor was a member of the legislature, he was a member of the judiciary, and a member of the executive. And because of that extraordinary linchpin that he had, and I've used that term myself as well as Lord Burnett, to describe it, he or she was able to have this, helicopter view of what was going on. And as it evolved, all right, we moved away from the Lord Chancellor being an active member of the Judicial Committee of the House of Lords.
Yes.
Probably fine. I think it depended on the type of Lord Chancellor.
It did.
And we evolved away from that.
You wouldn't want to turn the clock back.
And I don't think that Lord Chancellor needs to be head of the judiciary, by the way. And of course, they weren't before 1873. That title didn't exist. Now it's vested in the Lord Chief Justice. That's absolutely fine.
That's fine.
But I'll say this. I think that the Lord Chancellor should have responsibility for the money and the administration of justice. Plain and simple. I don't think it's right that
By that do you mean courts and prisons?
Yeah. Well, prisons, I think, need to go back to the Home Office, and there needs to be a separate immigration department.
Right,
so then the Home Office...
prisons back to the Home Office. Lord Chancellor has...
Lord Chancellor has courts, judiciary, legal aid, and also the Constitution. So pull that out of the Cabinet Office where it was put when Nick Clegg became Deputy Prime Minister. It used to be with when Jack was Lord Chancellor, he had constitutional law, because there'd been something called the Department of Constitutional Affairs that the Lord Chancellor had run for a little while, I think when Charlie Faulkner was Lord Chancellor. Bring all that back in, so the Lord Chancellor is looking after the law, even perhaps electoral law, really reinforce this sort of special role the Lord Chancellor has. But the Lord Chancellor needs to be a lawyer of standing. And I think if the Lord Chancellor is always a lawyer of standing, then the judiciary can have confidence that whoever's holding the office will not just have their best interests at heart, but will also be a guardian of the Constitution and get it right. And I think if you go back to that principle, and then you reform the court service to give the administration and control back to the Lord Chancellor, you then should scale up the human resources, the HR provision for the judicial office, which is the office that the judiciary is used to administer judicial matters. And then you've got that really clear demarcation, but you've got a strong Lord Chancellor who is able, with the authority and support of the judges, to be a real voice in government.
What about taking away running of courts from the judges entirely? You were explaining earlier it's a strange hybrid. Judges and ministers do it together.
Yes.
Would you take that away and give it to civil servants?
I think that, if you're answerable in Parliament, as I was, for the money and for the administration of justice, you've got to have your hands on the controls. And I don't think that the modern Lord Chancellor does. I don't think the Lord Chief Justice does, frankly, because between the two of them, it's left to some very good civil servants. I think the Nick Godwin, who's the Chief Executive now, he's very good. I work with him in other capacities. There's some great civil servants. It's not a personal attack. But this structure that was set up is only about 12 years old or so.
Yes.
It doesn't seem to satisfy anybody.
No.
And it does seem to me that as long as we're crystal clear about the judicial function, which is listing, which is the administration of individual cases, then I think we can make that change. Well, with this caveat, I've never seen a problem with a Lord Chancellor suitably informed to say, look, we're particularly worried about the child cases, for example. We'd like them to be dealt with as a priority. They're young, vulnerable people. We'd like them to be dealt with. Of course, that's been done very often. That is often the protocols that exist in court. But in order to say that to the judiciary, so that then
you're saying they should have that ability?
Yeah, I think they should.
Well, they do prioritise. I mean, we have riot cases that suddenly get priority.
Exactly. It needs to be a clear rationale, it needs to be explicable, it needs to be well evidenced, but I don't see a problem with that. As long as we don't start trespassing into individual listing or individual case management and usurping what always has to be an independent judicial function.
How did you find the judges? Do you think what do you think of them in terms of public perception? Do they have a good image?
Oh, well, they have an incredibly good image. I mean, all the public opinion surveys you see, the judiciary come out as some of the most trusted institutions, one of the most trusted institutions in this country. Why? Because we've always put ability and quality and merit at the top of our considerations when selecting judges. And I think that is so important. We are fortunate indeed to have a judicial system here in England and Wales, in Scotland and Northern Ireland, that is, I think, amongst, if not the best in the world. And that means that as a country, not only can we be proud of our rule of law tradition, but we're also a great place to invest. Because if you're an investor putting your money and your resources into Britain, you want to know that ultimately if something goes wrong, you've got an independent judiciary presiding over a legal system that actually offers redress of grievance. And that means that this country is a safe and sure place to invest. So the economic case for having a strong judiciary is also a clear one. And I get frustrated, frankly, when in the minds, it does seem sometimes, the Treasury mentality doesn't really think about the economic case for having a strong, robust and resilient justice system.
What about their diplomatic role as sort of judicial ambassadors, if you like? And I'm thinking particularly of sitting in Hong Kong. At the moment, that's a very controversial issue. A number of our former judges who were sitting on the Court of Final Appeal there, as you know, have pulled out.
Yes.
at least one still sits, if not two. What's your view about that?
Well, I think they're right to pull out. I think it's very important that we, as a government, did not put pressure directly on those judges to decide whether or not to pull out. In fact, when I was in office, together with the then Foreign Secretary Dominic Raab, we set out some parameters that we thought might be helpful for the independent judges to consider whether or not staying in the court was right. And that meant that, ultimately, whilst the decision inevitably is going to be taken in a political context, it has to be one that was made independently by those judges, particularly the serving Supreme Court judges like Lord Reid and others who at one time were sitting on the Court of Final Appeal. Because, unlike China, we're not a country where politicians can tell our judges what to do or, what appointments to fulfil. And I'm proud that the decisions that were made by, first of all, our serving judges and then by, of course, some of our retired judges were decisions that they made in a political context, obviously, but decisions that they made independently. And I think they're the right decisions because sadly now we're in a position, thanks amongst other things to the national security law in Hong Kong, that the Court of Final Appeal is providing nothing more than a veneer of respectability.
So Lord Hoffman, for example, who I think is one of those, he should step down or pull back.
It's a matter for him, but if I were him, I would pull back. I think offering a veneer of respectability to a draconian, anti-democratic and shocking development in Hong Kong law and justice is not a place that I'd want to be in. I'm watching a once proud special administrative region being underpinned by treaty, by the basic law, that is a living document. The Chinese think it's some sort of historic relic. It's a living instrument being totally ignored.
You're talking about the law that was drawn up and agreed when we handed over Hong Kong.
Yes, 40 years ago. It's a living instrument. It still applies. And it is a matter of, I think, outrage that that is being ridden roughshod over by the current administration in Hong Kong at the behest of their political masters in Beijing. It's a disturbing and alarming situation. We've got the Jimmy Lai case ongoing, a British citizen being held in a way that I think is unlawful. And we've seen, I think, as a result of the right decision made by the government I was a part of, to allow Hong Kong citizens to come and resettle in the UK, because it is no longer a safe place for democratic rights to be asserted.
So should Rachel Reeves be going on trade missions to China?
Well, I think our relationship with China has to be a very honest one. There are different layers and different approaches that we have to take in different contexts. But fundamentally, we have to face up to the Chinese and remind them that in many, many respects, they are not playing their part as a responsible world actor. A lot of the decisions that they make are having huge consequences, not just on people like the Uyghurs or the people of Hong Kong, but also on the rest of the world with regard to either the use of natural resources, economic imperialism, security concerns. You can't have a relationship with a country like China without being honest with them. They do not respect pussyfooting or kowtowing. You have to be firm, you have to be clear, you've got to be strong. And that's why I think that it's important that in many facets of our relationship with China, we've got to be quite direct with them about the problems that they are causing.
I'd like to ask you now, if I may, Sir Robert, about a couple of current issues. There's a big furore at the moment about grooming gangs, so-called, and increasing calls for an inquiry, another inquiry, a national inquiry. Is that something you support?
Well, first of all, let's get the term right. It's child abuse. And this has been going on in our country for a very long time. The particular manifestation of this type of child abuse has been in certain towns across England, but this is nothing new. We were dealing with this problem 10 or 15 years ago when I first came into government as Solicitor General.
You spoke about it in Parliament.
Yeah, I spoke about it. I spoke to the media about it. One of the first things we did was to suspend the Rotherham Council and send in commissioners because we were very concerned about their failings on child safeguarding. As a result of our interventions then. We changed a whole host of laws relating to social work. We reformed laws relating to taxi cabs, for example, because that was becoming a source of, frankly, sexual abuse and the trade in young women. And of course, there was a cultural change that was needed because these young women were just not being believed. They were coming to the police, and the police were making moral value judgments about these young women and disregarding them as if they weren't important or that their evidence wouldn't be believed, even though it's now 35 years since we changed the law on corroboration in sexual offences to allow for the voice of the child to truly be heard. And it seemed to me that in certain towns and cities in our country, that had not been caught up with, that good practice had not been adopted. And therefore, I think
we've still got a problem. So do we
still have a problem.
Do we need another inquiry, or is some other action required?
We have a continuing problem. I think that a combination is needed. I don't think we need a full fat J-type inquiry again. It took 7 years, and its recommendations have not been... An
inquiry as the one we've had under
Professor Baroness J. Really important inquiry. I supported its setting up. It was a Conservative government that set it up. It's reported. Its recommendations either need to be implemented, or
which they haven't been,
or there needs to be explanation as to why not. Mm-hmm. So that's number one. Number two, we have, I think, very effective local inquiries. So I'll give you an example. The Telford inquiry that my colleague and old friend Tom Crowther chaired was a very effective example of how locally, with an independent chair, obviously Silk, as Tom is, able to really engage with survivors and victims, talk to them, win their confidence and support, and then, in fairly quick order, in a few years, make a report with a host of recommendations that were then implemented. Now that seems to me to be a great model. It should be replicated in other towns. I think, however, there is merit in the intervention that my old friend Sarah Champion, the MP for Rotherham, made the other day, where she said there needs to be some joining up mechanism to make sure that these different inquiries are actually more coordinated.
Feed into one another,
yes,
learn from one another.
I think that there's a very good case for that. So let's look at that mechanism, but let's not try and reinvent the wheel and just kick this current issue into the long grass.
Tougher sentences, do you think that's something you raised when you were in Parliament?
I did.
Tougher sentences for the perpetrators of this abuse?
I think there's plenty within the existing criminal law to allow judges to increase sentences where they see appropriate. There are plenty of aggravating factors that would apply the vulnerability of these victims, the fact that they're being targeted because...
Should race be one of those aggravating factors?
Look, I tell you what, I think race should not be a mitigating factor. And I remember saying as Solicitor General a few years ago, it doesn't matter about the ethnicity, we should follow the evidence and sentences should be passed, irrespective of ethnicity. Because, sadly, there's evidence that there are a number of certain Pakistani Muslim groups doing this. There are also people of other ethnicities who are involved as well, let's not forget. But the point is the law should not discriminate positively or ignore the prosecution of cases because of so-called cultural sensitivity. That's the problem.
Has it been?
I think that we went through a period probably about 15 or so years ago where we were still coming to terms with changes in the law about racism and racial discrimination. And I think some of our agencies at a local level were a little, should we say...
nervous of it?
Nervous, institutionally shy, a bit frightened about facing up to the fact that some of the problems were coming from particular ethnic groups.
Yes.
And there can never be a cultural excuse or explanation for child abuse. And whilst I think I'm not accusing agencies and government, local government, of deliberately or willfully being complicit in trying to minimise responsibility, I think there was a nervousness, there was an inexperience, perhaps a shyness that I think has largely washed its way through the system, but which we need to make sure is not repeated, so that there is a robust approach that is on the side of the victim, that makes sure that if a young woman in those circumstances walks into a police station, that she is listened to, that she is supported, that she is looked after from second one in order to make sure that her story is told and that those responsible face justice.
An unrelated issue, assisted dying, assisted suicide, some call it. What is your view about that? We now have legislation which is going to work its way through Parliament.
I think the proposed legislation is no, it's unworkable. I think that to pick an arbitrary 6-month period is fraught with difficulty, and we're putting huge pressure, first of all, on medical practitioners to come up with a conclusive view that very often won't be right. And it's not their fault. It's very difficult to predict timings when it comes to this. There's no reference in the bill to suffering, which of course has led to other people to saying, well, what about us?
Exactly.
What about us? So the bill is discriminatory.
But you wouldn't want it widened. You wouldn't want it at all.
No.
Is that your position?
I wouldn't want it at all. And because I think also this faith in putting a judge in charge of making sure that I think we're asking a huge amount of our judges. First of all, are we convinced that there's capacity and resource available? 2, are our judges really, equipped to be, in effect, arbiters of such a morally fundamental question? I have a huge faith in our judiciary, but I think there's far too much of a tendency in certain quarters to sort of elevate judges as sort of, well, a judge will do it, as almost a demigod status.
It's a big burden.
It's a huge burden, and I think it is wrong. And already we're seeing, I think, statements having been made by proponents of the bill being rowed back upon, a lack of clarity precisely about what's happening. And I also, I'm afraid, am very critical of the government's position here. At the outset of the introduction of this bill, I wrote to the Cabinet Secretary because I was very concerned that the government didn't seem to have a position on the detail of the legislation. It's all very well for the government to say that members of the government will be free to collective responsibility. That's absolutely fine. That applied during the EU referendum, for example. However, this is different because they've got a specific bill that has been introduced, and the government has a duty to respond through the Public Business and Legislation Committee, the PBL as we call it, to come to a view as to what its position is on the bill. If they're neutral on the bill, well, that actually has a significance because that means that they probably won't then oppose its passage through Parliament. But they need to be very clear, and they needed to have done the clear detailed work that you need to do on every bill in order for the government to have an informed legal position. Now, I don't see that as having been done at the right stage, and I think that therefore this bill seems to be being rushed. And for such an important issue, that I think about this issue regularly. We've all got family experiences. We all think about our loved ones. We all think about dignity in dying. But we also should think about the wider impact this has upon the way in which we as a society not just view death, but value the quality of another person's life.
Where do your own views about it come from? Do you have a religious faith?
Yes, I do.
And does it come from that?
It's partially informed by my faith. And can I say this? I think it's wholly wrong of people to criticise, for example, the existing Lord Chancellor because she has a faith and that faith might inform her view. Well, utter nonsense. Of course she's entitled to have a view partially informed by her faith. I certainly do. But I'll say this as well. It's also informed by the fact that I'm a parent of a disabled adult. And listen to the disability spokespeople. Listen to people like Baroness Tanny Gray-Thompson, who's extremely concerned, rightly, that legislation like this, however well-intentioned, and I think it is, inevitably affects the way in which we start to assess the quality of life of other people. We have no right to assess the quality of a disabled person's life.
Your daughter is autistic, and you've spoken a lot about autism, and you champion various organisations, associations you support.
That's right. And what really disturbed me was that there was a terrible case in Canada recently where an autistic person was allowed to go through the assisted suicide path. And it seemed really that it was all about the autism and not about anything else. And, that worries me because we do not have the right to ascribe a value to another person's life. And, if people are going to be honest about it, is that what they're saying? Are they saying, well, we can't anymore as a society be burdened by the chronically sick, the very elderly who require a lot of care, disabled people who are in high need? I mean, if we are going to go into that sort of society, well, Lord help us all. I think it would be a dystopian nightmare. And that's why I worry about this bill being the product of quite a swift process, or without the checks and balances that I think are really needed in order to make good law.
The state of the Conservative Party. Is Kemi Badenoch going to be able to see off Nigel Farage?
Well, I think the first and most important point is that Kemi Badenoch should not fixate on Nigel Farage, and I don't think she is. I think she's clever enough and able and gifted enough to understand that the solution to the problems of the Conservative Party does not lie with other parties. It doesn't lie with aping reform. It doesn't lie with trying to be, a Labour Party Mark II. What it relies upon is the Conservative Party rediscovering its confidence and its ability to develop policy, and then rediscovering its competence, for which it has historically been valued, but which in recent years has been in short supply. Now, if we can get those two right, the two C's, if you like, right, then I think other things will start to follow, and that the party will rebuild and regain its position, not just as a viable contender for government, but at the heart of our political life, representing, I think, for me, always as a Tory, as a Conservative, what I think are the best values about this country, and why Conservative governments have consistently succeeded in helping make this country the wonderful place that it is.
Well, she's not doing that at the moment, is she? She's not managing to instill that confidence. And
she's only been in for a few weeks. I mean, give her a chance. You've got to take a long view. I mean, this sort of 24/7, short attention political span is very frustrating if you're trying to rebuild the party, as she has to do.
And can she?
I think she can, and I think she needs to be given the time and the space and the support that a new Conservative leader frankly deserves. She won a clear election amongst the membership. She was the candidate who had the most MPs supporting her. She's got those two in place. Let's give her some time and space and support her as we rebuild the Conservative Party.
Will she lead the party into the next election?
I very much hope so. I don't want yet another change. We've had too many leaders in the past few years. We need to give we need to value continuity now, and we need to make sure that under her leadership we are working together, we are developing the policies that we need for the next election, which isn't going to come for another 4 years, and that the party is in good shape, both organisationally and intellectually, to make the case to people to say, come with us. We have the answers. It's easy to be, populist and to make slogans that sound good in the pub, but actually on close examination don't mean anything. Or you can be a supporter of a rather humourless, grey, drab, and not terribly competent Labour government that won this huge majority but doesn't seem to know what to do with it. There's an open field here in politics at the moment, and I very much believe that Kemi is a person who can exploit that and bring us back to success.
This podcast was brought to you by the University of Law. Subscribe now to make sure you don't miss the next episode.